They must know something. That's all I could think. They need to get out of here. I'm happy for them. This is a case involving a termination of parental rights case. I would like to reserve 5 minutes because my intent is to spend as little time as possible on the facts because I think they're well outlined and are pretty well defined by photographs and videos that have been submitted to the court in the record, and concentrate on where we think that the court went wrong with regards to the application. This case involved initially an 11-month-old child who was taken from the mother and the father. The father in this case is still incarcerated. His rights were terminated by the court. The mother, who was charged in criminal matters also with the father, was a participant, and her rights were not terminated, and we think that that was an error based upon the application of the best interest factors in this case. The court found, as the court is aware, the court found predicates for the termination of rights. There were several, and it had to do primarily with I think the conditions that the child was in, and actually presenting the child with danger. If the court looks at the record, and I know you have, the mother in fact testified that she acknowledged that the child was at risk of death by being in their care. Before I get into the law, which is really where I want to spend my time, we had drug abuse going on, we had meth going on, we had drug, we think, found on the child's bed, feces in the bed, prostitution going in the house, which was in the household, which was intended to be able to continue the drug use. Child was found to be drug exposed, and the child, at some point, the records demonstrated, was found to have herpes. This child now, and I was looking at it, it's very interesting. Child was born December the 27th, 2019. Child is now, excluding this January, 72 months old, has lived with the current parents, not parents, but guardians for the past 61 months.
Counsel, something that struck me as different about this case than many of the parental termination cases that come up here is here the trial court found that there was still a strong and important relationship that continued to exist between the child and the mother, and seemed to find great import in the testimony that relationship was only building and strengthening. And so while we do have this time period and the child's been in the custody and care of the grandparents or grandmother and because of the awful circumstances that existed, and isn't the trial court essentially looking at best interest and saying there's a significant, meaningful relationship here and all the evidence points towards it improving rather than having really that tie's already been cut?
You know, this is one of those situations where you wish you could, and I attempted to bring forward things that have occurred since this trial court took place, the decision, because what happened with regards to this case was this resulted in a remand basically to the juvenile court of Montgomery County. There was a trial in the juvenile court of Montgomery County as to what should happen with regards to this child and the findings that court made. Those issues are not before this court, but I will tell you that court indicated that we're not increasing anything. There was significant testimony with regards to counselors, including Janie Berryman, who is someone who's typically known by local courts. And in that situation, the court, and again, applying juvenile court rules in part, said this child is at risk of danger. You get 2 hours a week. And that's what's going on. So, you know, when I look at it, I'm struck by what I consider to be the misapplication of the law in this case, because it's not just is there in fact the potential that there be some sort of relationship. We've now subsequently tried that case again. What I think.
So you're saying a misapplication of law then. So your argument is not founded on the idea that the evidence preponderates against any of the trial judge's findings.
No, I think it does preponderate against the findings of the court with regards to the child. And the reason that I feel that is that I don't think the court looked at this case Audrey S. And in that case, what this court said, you've got to look at the stability and the potential future of the child. You don't just look at one thing, you look at everything, and you look at what's going to provide the child with the greatest stability, the greatest potential to go forward in a successful way. You've got to look at what's going to happen with regards to the child.
But counsel, here isn't a factual determination if the trial court says there's a meaningful relationship. All signs point towards that relationship improving, that mother can provide a safe environment for the child. And may disagree with those factual findings, but aren't those factual findings?
They are, and they are preponderated against by what the evidence was. What we had was, after, I think it was 3 years, the court said, okay, I'm going to send you to a place called Open Door, and you get to go for 2 hours. And my clients, who are the real parents of the child at this point, in my opinion, would pump the child up, get ready. And that's what the testimony was. You're get ready for this. We're going to go. It's going to be a fun time. I'm going to drive you there. You're going to be good. And they go someplace that is safe, that is supervised, and it works. That's not, in my estimation, what the law intends. The question that was, in my mind, omitted by the court is, how does this stability, how does the future, how does that look in terms of what's been there before?
Well, what about the trial court's findings with regard to, for example, the home environment? So the trial court made factual determinations that mother had space for the child, had purchased items to care for the child, and I believe there's a factual finding that mother had essentially a safe space and what was needed to be able to safely care. And that sounds like a factual determination to me.
The factual determination was made with regards to the child seeing the mother for 2-hour periods supervised by an individual who was purportedly a professional. In the subsequent case, they were kind of viewed as not being professionals. But in terms of that case, there was nothing that was presented to the court that the child was, since being taken, in the mother's care, in the mother's home, cared for by the mother, fed by the mother, supported by the mother. None of that was presented. What was presented was the opinion of a group in Springfield called Open Door that observed 2 hours of residential, not residential, but visitation. So, you know, and again, that's part of why I reserved time, because I think in part it is a legal matter. That is not sufficient basis, taking into account the dramatic circumstances that this child lived in for 11 months. And I encourage the court to look at the photos. I encourage the court to look at the testimony of the Clarksville Police Department, Adam Liberatore. We don't get to say, in my estimation, oh, it's all better now. It's all good. What has to happen is you have to look at what the statute says. The prompt and present placement of the child in a safe environment is presumed to be in the child's best interest. The court didn't place the child. This court didn't act to change placement. The court said, okay, you're going to continue the 2-hour residential visitation, and then you're going to go back to juvenile court. So in essence, what we do is we go back there and we try this case again, and in that court they made all kinds of determinations, including morality, continued drinking, things that were not appropriate.
Well, but here we've got a finding from the court that says mother's present mental or emotional fitness would not be detrimental to the child or prevent mother from consistently and effectively providing safe and stable care and supervision. I mean, we've got that finding.
Understood, and we are challenging that specific finding, because if you look at, I defy anyone to look at the history in this case. Drug abuse before the child was born, drug abuse after the child was born, drug use in the home, child having herpes, child being drug exposed, rats in the child's bed, prostitution going on with the child in the house.
Counsel, wasn't the trial, mother testified essentially that she's a changed person here. Isn't the trial judge entitled to believe her? And our review And given the deference that the trial court is entitled to, and how do we look at that determination and say, no, you got it wrong based on this record?
If you look at the record, and I wanted to talk more about the law, but if you look at the record, what the record demonstrates, and again, I don't put myself in the place of the judge, but I don't know how you cannot look at what the record was with regards to the child pornography that was going on, with regards to prostitution, with regards to the drug use, with regards to the child having herpes, and then say, oh, it's all better. 2 hours. You've seen the child for 2 hours. That's what the mother sees the child now, 2 hours. And I don't know how, looking at that and looking at the history in this case, which is, and taking into account what I think the court has to take into account, which is who is going to provide the stability and the safety in taking care of this child. And that's a paraphrase of what the law is. But that is, in essence, what I think the court had to do, and that is the mistake that I believe the court made. It's a leap of faith that is not supported by anything in the record.
Thank you.
Good afternoon, Your Honors. My name is Daniel Ufford, and I represent Michaela Seneff, who is the appellee in this matter. She's the biological mother, and she is here present. As you can see, she's been present at essentially all court proceedings relating to both this matter and the juvenile matter. I would like to start out, before I get into my summary, by stating that it appears that Mr. Olson is arguing concerning custody of the child, which his clients do still have. He is not arguing related to the specific law that is applicable to the termination of my client's rights, parental rights. This case raises the issue of whether it's in the best interest of Liam to have his mother's rights terminated. It's not a case of first impression to this court. The case that I mostly rely on in my brief is In re Gabriella D., which came all the way up to the Supreme Court and was determined on facts very similar to this. I will say in that case that the mother's history was much more sustained. It was just as significant, arguably, but it was much more sustained over a long period of time. In fact, it even crossed borders of 3 states. So in that respect, I do think that it is a case where there was even more magnitude concerning the malnourishment, neglect, and abuse. There was a drug addict mother, a drug addict father, domestic violence in the home. In that case, the court found that the circuit court determined correctly that the children should go back to the mother, considering the significant bond that they had.
Did this court, remind me, did this court send the children back to the mother, or did they just continue what was going on?
The Court of Appeals?
No, the trial court.
The trial court, there was a little bit of an aberration there in the facts, and I do believe that was before the statute was modified concerning staying the proceedings. I'm forgetting that off the top of my head. I know it's subsection F, but that there has been a modification in Gabriella in that. But in that one, the juvenile court that was initially
I'm not
involved,
talking about Gabriella. I'm talking about this case.
Oh, in this case.
In this case, did the trial judge order the mother to get the child back, or did they just continue seeing how things were going?
The trial court in this matter just determined that her rights were not to be terminated. It was not in the best interest, and then it went back to the juvenile court, which Mr. Olson has referred to, and there was a custody determination since then.
Yes, that's not part of this, though.
Right, correct. And so in re Gabriella is synonymous in the fact that the significant bonds were there. There was testimony from experts, both from DCS and other organizations that said, hey, this is in the best interest of this child. There is a significant bond. What Mr. Olson seems to not want to refer to is that before the TPR, the petition to terminate parental rights, was filed, there was also therapeutic visitation where a master's level social worker was therapeutically involved in the visitation, and that was done through the DCS during those proceedings in juvenile court. Based on several months from August 2021 to March of 2022, the recommendation was made through them in DCS that the child go to unsupervised visitation, still in the custody because there are still criminal proceedings going on and so forth, but still in the custody of the appellants. And it was when that recommendation was made that they actually filed the petition to stop that from happening. So there was already a significant bond before the filing of the first petition. That petition actually went on for quite some time until late 2023, where they non-suited and immediately refiled, which is the petition upon which is before the court now. But that is a part of the history of this case that is very significant. So there was a significant bond going on that was severed and stayed as the result of the filing of the first petition, and then later, before the circuit court in this matter, it was determined that that should be resumed, and that's how Open Door got involved, and they did something very similar. The master's level social worker in that observed very similar behaviors by my client. It's detailed in the testimony that they had instantaneously, even given the significant period of time that they had been apart, which at that point I believe had been almost a year and a half. He instantaneously recognized his mother, instantaneously went to her, and they had very appropriate interactions, redirections, were able to play together, and they were supervised. We're not contesting that. They were supervised. They did, over a sustained period of time, turn into unsupervised in the community, and that's where she's at right now, because that's what, I don't want to get too much into that, but it's not about the custody proceeding, but that's what the juvenile court judge ultimately determined concerning ongoing visitation. So in that respect, it's a very similar case to Gabriella, where we've got these professionals that are involved that are non-parties, and we've even got fact witnesses that are involved that aren't experts, but that made observations during this time, at least 4, who all testified and observed that my client's behavior was appropriate, and that my client and the child seemed to have a very good bond, and that severing those parental rights would be detrimental. And so I think that's what we've got here that sets the precedent. And I think that's what our trial court judge was looking at, was very, very determinative in the way you read that opinion, and each factor is very thorough. Definitely weaved in everything that came from the trial. Do I disagree with some of the analysis? Yes, because some of it does paint my client in a bad way, but you can't defeat the way that this case started. My client has admitted the entire way in her deposition, in the DCS proceedings, the juvenile court, before this was filed. Even in her testimony at trial, she absolutely acknowledged that the situation that she was in with this husband, who is the appellate grandmother's son, who is now in prison for child pornography, and she's divorced from immediately, while she was in that very short period of time, just a matter of months. They were barely married for a year before this happened. And
Counsel, the determination in this case that
Yes.
there's an important continuing bond, that bond looks like it's strengthening rather than weakening, that mother can provide a safe and stable environment. Are those all factual determinations in this case? Or are they legal determinations that are being made in this case?
In my opinion, they are definitely factual determinations. I believe that our trial court judge definitely weaved in what was in the record and what came before her. She was not making a custody determination, and she was very clear about that. Our judge was. She essentially concerning the visitation, she just continued what was in place before the petition was filed, so it wasn't a custody determination.
And in addition to testimony that's opposing counsel raises that sort of other witnesses are limited in terms of the scope of what they can observe in terms of time of supervised visitation. The trial court here also heard from mother in terms of her own testimony related to change circumstances in the environment that she felt like she could provide in this case, I presume.
Yes, it was very lengthy. She was actually the very first witness. Her deposition was entered as the very first exhibit before she even started testifying, and that's how the trial began, and it was a very lengthy direct examination. And she did, it started out with, how did we get here? And Mr. Olson refers to the record. If y'all want, your honors view that, and I expect that you would, or if you already have, you know the shocking nature of how this case began and how Liam was removed from the custody of my client. That has just been used as a bat to whap her over the head throughout the entire proceedings. In every proceeding that we have, it's absolutely determined by Mr. Olson and his clients that it is an unforgivable situation, irredeemable. But she testified about that in the beginning. And then she did, especially through my cross-examination, that she got to present the evidence of where she's been since then. And then what she testified about concerning addressing the drug addiction that the biological father exposed her to, the deplorable conditions that she had put her child in, everything that she had done.
Am I recalling the record correctly that mother has passed all of her drug tests as of the time of trial here, that when she sort of went into treatment, that she's passed all, that she hasn't had any failed tests here?
Yes, she's passed everything. In fact, just to get to that part of what happened with the resulting criminal charges, Detective Liberatore did investigate a severe, incredibly discouraging case, and unfortunately my client was involved in that. It did end up that culpability mostly fell on the father. My client, unfortunately, was complicit in a lot of what took place, but she was in an abusive relationship. She was trapped, according to her testimony, but she still acknowledges her responsibility to that. Ultimately, those charges, the most serious charges concerning child pornography, were dropped against her, and she pled guilty to neglect and was put on judicial diversion, which she has since completed. She hadn't completed, she still had a little while left when this case concluded before the trial court, and she passed all drug tests. She's passed all that now, and there's been no indication that she is continuing in that lifestyle at all. And so in that respect, she has met all those marks of showing for a sustained period of time even that she's not going to go back to that lifestyle. She even participated in being a peer recovery specialist, so that requires some very special certification and obviously passing drug tests in order to do that. So for that period of time, which I believe was almost a year or a year and a half when she was working doing that, obviously she was putting that past behind her. She's divorced the husband, doesn't have him around. She waited a significant period of time before she got romantically involved with anyone else. Her current boyfriend actually testified at the trial too. The judge found him to be a very credible witness and of good character based on the brief amount that she mentioned him in the opinion. So in that respect, I believe that she's done everything that she can. The problem with the argument of the appellants really comes down to, they say this is unforgivable, irredeemable. Case law is just very clear that that's not the standard, especially if you look back again at Gabriella. Yes, deplorable situation. The most deplorable part of the Gabriella case was that you had a young child that was significantly malnourished, to the point of physical detriment. And in that, the court still found that despite the past circumstances, the mother finally moved forward, got rid of the abusive father, severed ties with him, and took every action possible to continue maintaining the relationship with the children, and did so in a to the point that she did have a significant bond and had demonstrated that she could continue to care for those children. And so in that respect, her rights were not terminated. It's clearly against public policy. Gabriella, I believe, cites Bentley and N. Ray Audrey S. in citing that standard, that it's untrue that that the standard is that somebody can do something that's absolutely irredeemable when it comes to terminating parental rights. Once that happens, they can redeem their lives, and that's exactly what my client did. She failed a drug test for methamphetamine the night that Liam was taken, and since that point forward, she has done everything to create a trajectory away from that lifestyle and to build a lifestyle where she can be a good mother for Liam. And that's essentially what the trial court found. If I may, I also brought up in my brief the frivolousness standard that may be applicable, and I just want to briefly argue that. It's even been demonstrated today that Mr. Olson wants to continue to focus on the custody determination and not apply the correct law to the best interest of Liam. And he's also brought in post-trial facts that this court has already squarely rejected and said is not applicable in this case. His motion was clearly denied. And so in that respect, this appears to just be an exercise of delay and cost that really, it doesn't even bring about a justiciable issue. It appears in his argument that he even had difficulty getting opinion out of it and applying facts to this case like the court did and like his brief failed to do. So in that respect, my client has had to continue to pay me in order to respond to a brief that didn't cite any law, that didn't cite the record, other than a statement of facts. And so in that, and also the delay part of it is that it was delayed essentially, I believe, about 10 months in order for a brief of no substance and I guess to maybe essentially try to get those post-trial facts in that this court obviously squarely denied, and it wasn't even applicable under the standard that it would have been admitted. So in that respect, I believe it's both a frivolous appeal and one that delays time, which is the standard under the statute. So with that, I would ask that the trial court's opinion not terminating my client's parental rights be affirmed, and also that this appeal be found to be frivolous and my client entitled to damages. If there are no other questions, I'll yield.
Thank you.
Thank you.
Mr. Olson?
Briefly to respond to what counsel just addressed. What he's talking about now is exactly the kind of thing that I think this court has to look at and is squarely in the record. This incident that involved this was a multi-month drug escapade by this lady. The question becomes stability, and should the court look at this and say, looking at this from the best interest of the child, what's the best for the child? And that's what Audrey S. basically says. Respectfully, what he admits is, this is the second incident. We introduced, as I recall, a photograph of the young lady, and I'm glad she's doing well here today, and she's done well before and then fallen back. We introduced a photograph of her in the hospital, overdosed on drugs, that was taken, I believe, by her grandmother, that's in the record, that predated her meeting this gentleman named Tyler and predated the birth of this child. That is the kind of thing that we felt was important to look at for the purpose of determining from the position of the child, what is the best interest of the child? And again, looking at the statute says stability, 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 stability. I've done so well while I've been under probation. Isn't it amazing how stable I've been under probation? Of course, when I wasn't on probation, I overdosed on drugs. Then when I was in the Army, I overdosed on drugs. And then when this child was there, I engaged in all the things that I've discussed, and I won't go through that again. I bring your Honor's attention to one thing that I felt was the best. And I told this lady when I asked her the question, I said, I'm going to throw you a softball. I'm going to say, why is it that you think that this child should be in your care rather than staying with the people who have provided care for the child 60 months of the child's life? And she said, because I'm the mother. It wasn't, I can do it better. It wasn't, I'm going to provide great stability. It wasn't any of those things. It was, I'm the mother. And respectfully, I respect the lady for having tried to come back. I hope she's doing well. I wish her Godspeed. But that's not really what we're here about. We're here about today from the perspective of the child. Is it in the best interest that this child's be returned in some fashion at some time to this mother?
Counsel, in terms of addressing whether preponderates against, part of your initial argument here was related to scope, right?
Right.
In terms of the idea that there's only observation during limited time period.
Correct.
But I'm thinking about opposing counsel's argument here, and when notes that mother passed her drug test, mother got a job, and isn't this way beyond testimony related to somebody who saw her an hour or two during a visitation? It's also related to a lot of supporting evidence like those past drug tests and having obtained stable employment. And doesn't that also enter the mix when considering whether the evidence preponderates against the trial court's findings with regard to stability, safety, improved relationship, all of that?
My impression, it all goes in, but to look at that and say, oh, you're better, omits, when I was alone, when I was single and lived in another state, I overdosed on drugs. Here's a photograph.
But the court made findings on that, right? I mean, I'm looking at the order right now. There's findings about that.
Sure.
So you're asking us to basically take those findings and evaluate them differently than trial court. That's not what we do.
Well, respectfully, I think that the standard in this case is you take the facts and you apply them unless preponderates against them. And in this case, drug abuse in the Army when you're being observed by the folks in the Army, drug abuse when you have the child at home. I mean, the only time that this woman has performed has been when she was on probation and was being observed. And that is not, in my mind, the standard that says, oh, you're better now. It's best for the child to go back to someone who used drugs throughout this time. And it's not just using drugs. It's really not. There's extensive.
Well, I mean, you still, I've quoted you the finding from the court's order,
Sure.
and you've still not pointed to evidence in this record that shows that the findings preponderate against that finding that I read. I mean, I just don't see it.
Well, what the court says is basically that it's in the best interest of the child to not terminate the mother's rights. And in looking at that, the statute, I think, what is it, 36-1-113, you have to look at it and say stability, the ability to care for the child, all the different things that are there. Respectfully, the court looked at a record that is absolutely devoid of any positive discussion other than 2 hours at open door supervised and a boyfriend with whom she lives. That's the total totality in my estimation of what the evidence was. And the overwhelming evidence from the man she lived with, this fellow Tyler, the overwhelming evidence from the police captain, Adam Liberatori, the overwhelming evidence with regards to the conditions in which the child was found. Respectfully, you have to look at that, and part of what your honors can do is make a determination whether or not the facts were properly applied and the law. And in this case, I believe both were misapplied.
Thank you very much. Thank you very much, too. That ends today's docket. Would you please adjourn court until tomorrow?